Hello, my name is Maya Al-Katib Shami, and I'm the Managing Director of the Human Rights Institute at Columbia Law School. I'm delighted to welcome you to this event on behalf of the Institute, and thank you for joining us at this event. I would also like to thank our partners in organizing today's event, the Institute for the Study of Human Rights Indigenous Peoples Rights Program at Columbia University, the Columbia Society of International Law, and RightsLink. This is the second event in a series on culture and human rights curated by the Human Rights Institute here at the Law School. The series brings together influencers, activists, and leaders and scholars from around the world to share critical perspectives and innovative approaches in the area of culture and human rights, with a focus on resistance, protection, and priorities. Today's event will focus on cultural rights and international law, including historical shifts and current developments in the protection of cultural rights internationally. We are honored to have with us Ms. Elsa Stamatopoulou, who has authored a pioneering book on the subject and was in the middle of international developments around cultural rights in international law within her former role as the chief of the Secretariat of the UN Permanent Forum on Indigenous Issues. Ms. Stamatopoulou is now a professor at Columbia University and the director of the Indigenous Peoples Rights Program at the university's Institute for the Study of Human Rights. Her background is in international law, criminal justice, and political science. She worked at the UN for 31 years before joining Columbia University, with some 22 years focused on human rights, and in addition to 8 years exclusively dedicated to Indigenous people's rights. Ms. Stamatopoulou received numerous awards for her accomplishments in the areas of peace, justice, human rights, culture, and the arts. We are truly privileged to have her with us today. Please join me in welcoming her.
Good morning, everybody. I hope you're enjoying your pizza. I would like to thank, first of all, the Human Rights Institute. Can you hear me? Yes. For this welcoming invitation. And I would like to pay tribute to the memory of the beloved and famous constitutional law professor at Columbia Law School, Lou Henkin. And in this very room, I was attending his lectures, and I had the honor to have him as my mentor during my research on cultural rights. And Lou Henkin was the first person in the United States, in a United States university, to teach human rights, 1971. And I often say it took about 40 years at Columbia University to teach Indigenous people's rights, but that's another conversation. At the UN General Assembly in New York and at the Human Rights Council in Geneva, we have had a number of inspiring developments, including regarding cultural rights. The Special Rapporteur on Cultural Rights, Professor Karima Benoun, has presented reports focusing on the deliberate destruction of cultural heritage in time of conflict and in time of peace, the impact of fundamentalism and extremism on the cultural rights of women, the impact of fundamentalism and extremism on the enjoyment of cultural rights, the cultural rights approach to the universality of human rights and the close interrelationship between universality and cultural diversity, and the contribution of artistic and cultural initiatives to creating and developing rights-respecting societies. And most recently, her most recent report this fall is the importance of public spaces for the exercise of cultural rights. So cultural rights are included in the Universal Declaration of Human Rights, the International Covenant on Economic, Social, and Cultural Rights, and other human rights instruments. However, while academic teachings and policy work in the human rights fields have been focusing on civil and political rights and increasingly on economic and social rights, somehow cultural rights have been lagging behind. At the same time, cultural studies have been thriving. For a long time, little attention was devoted to cultural rights by states, international human rights, and other bodies. Why this neglect? What are the special difficulties that human rights have presented? What has changed over the past few years so as to open up theoretical and political spaces for cultural rights to be explored as human rights? How would things be different if we were to take cultural rights seriously? What effect might they have on responses to challenges like massive migrations, expressions of cultural polarization and cultural politicization, fear of loss of identity and cultural extinction, ethnic conflicts, and the threats of globalization? Cultural rights pose a disciplinary epistemological challenge. From an epistemological point of view, cultural rights require a dialogue between at least two human sciences, anthropology and the law. Although, thanks to our human curiosity, we are pleased to get a taste of what other disciplines think, we often don't get to dialogue with each other among disciplines. Let me explain further. Human rights have historically been a point of disagreement and tension over the decades between anthropologists and jurists, fortunately with diminishing fervor. Because in terms of methodology, jurists tend to generalize, to make abstraction in order to imagine, create, and implement the normative framework of a society, while anthropologists tend to analyze the specific in order to understand deeply the fabric of a given society and its most internal ways of functioning. I believe that those angles are complementary. Going back to history, when the UN was drafting the Universal Declaration of Human Rights in 1946 to 1948, the American Anthropological Association announced that in its view, there could never exist a truly universal declaration because not all societies have the same view about what human rights are. After many years, in 1998, at the 50th anniversary of the Universal Declaration of Human Rights, the American Anthropological Association formally changed its position and adopted the resolution expressing its support for the Universal Declaration of Human Rights. An extraordinary meeting point of collaboration between these two disciplines has been the area of human rights of indigenous peoples, starting in the 1980s. Since then, people from both disciplines have been supporting the global indigenous peoples movement. I would like to admit that my dealing with cultural rights puts me often in a difficult position. For my fellow jurists, and I'm very happy that I am among you, things that have to do with culture may seem rather vague, since one of the aims of the law is normative clarity. And in the best of cases, jurists may see things related to culture as secondary by comparison to what they see as the hardcore of the law. While for anthropologists, juridical discussions may seem formalistic and superficial. Imagine now that for classical jurists, the field of international human rights law is seen as weak law, semi-law, let us say. Now, for human rights jurists, cultural rights take this position of weakness and vagueness. We can therefore see how low cultural rights are in the hierarchy of understanding and interest, even among human rights experts. In other words, there has been an awkwardness about these rights. In my introduction today, and I need to apologize for being kind of telegraphic in order to go through this dense material, while there is a lot of human pain and joy behind these human rights that I will talk about. So I will speak in 4 main points. First, why have cultural rights been neglected? Second, a brief legal history of cultural rights. Third, what is the normative content of cultural rights? And fourth, why are cultural rights especially important today? First, why have cultural rights been neglected for so long? The reasons can be summarized as follows. One is the challenge of the definition of culture. versus the requirement of specificity for the formulation of human rights as legal categories that can create corresponding obligations on the part of the state. Second, another reason is that for human rights thinkers and advocates, cultural rights have evoked the possibility of undermining the universality of human rights. Third, another reason is that for many, cultural rights are thought to be a luxury, something that we can seek after we ensure our other basic rights. Others have been ready to see culture as a commodity, to be bought and sold, but have not been ready to see the moral and thus the human rights aspects of cultural rights. And fifth, for several states, cultural rights raise the scary spectrum of group rights or collective rights, minority rights, that the state is very defensive about and feels existentially threatened from. Second point, what is the brief history, legal history of cultural rights? Article 27, the drafting history of Article 27 of the Universal Declaration, what did I do? Okay. So one moment so that you can see. I have put some texts up because sometimes it's okay. I think I'll go on while we are doing this. Okay, we can put the. So it worked. Scroll down. Okay. Okay. So the debate, the historic debate around cultural rights was connected to the debate on minority rights in connection with the Article 27 of the Universal Declaration of Human Rights, which reads that everyone has the right freely to participate in the cultural life of the community, to enjoy the arts and to share in scientific advancement and its benefits. Everyone has the right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he is the author, he or she, right? They didn't know this she at that time. So this article, through the inclusion of the word "the" before cultural life and community, does not present a commitment to diversity and pluralism, assuming somehow that cultural participation will take place in the one culture of the nation state. The question about the inclusion of the rights of minorities did arise in connection with that debate. Already they had a text at the Commission on Human Rights. In the mind of the drafters of the Universal Declaration of Human Rights, protection of minorities would normally include both protection from discrimination and protection against assimilation, and in particular protection of ethnicity and language. Please hear me when I stress constantly here how often the word language pops up in this presentation, because these are what the texts have told us over time, which express, of course, the will of states. So, the text that was debated originally provided for the right of persons belonging to ethnic, linguistic, or religious minorities to establish and maintain schools and cultural and religious institutions, and to use their own language in the press, in public assembly, and before the courts and other authorities of the state. However, this text was never adopted. It is dramatic to realize how these cultural rights have remained burning demands and rallying points for indigenous peoples and minorities to date. The drama of the debate on cultural rights, which encompassed the debate on minority rights, has another revealing angle as well. Please stay with me on this. It was connected with a convention on the prevention and punishment of the crime of genocide that was being drafted by the UN General Assembly's 6th Committee, simultaneously with the Universal Declarations, in another room. There was a proposal during the drafting of the Anti-Genocide Convention to include in the definition of genocide the intent to destroy in whole or in part, cultural groups, as well as national, ethnic, racial, and religious groups. In other words, to include cultural genocide, along with physical or biological genocide. The proposed Article 3 of the Anti-Genocide Convention read as follows. In this convention, genocide also means any deliberate act committed with the intent to destroy the language, religion, or culture of a national, racial, or religious group on grounds of national or racial origin or religious belief, such as 1. Prohibiting the use of the language of the group in daily intercourse or in schools, or the printing and circulation of publications in the language of the group. 2. Destroying or preventing the use of libraries, museums, schools, historical monuments, places of worship, or other cultural institutions and objects of the groups. The proposal on cultural genocide in the context of the Anti-Genocide Convention at the Sixth Committee was finally put aside. And also the Universal Declaration of Human Rights did not include any reference to minority rights either. This tumultuous history of Article 27 may well explain much of the silence on cultural rights over the decades, to the extent that the original reasons for resisting them for minorities and indigenous peoples still remain for many states. But in today's interconnected world of greater expectations for democracy and rising cultural identities, avoiding the respect for cultural rights can only lead to frustrations in society and instigation of conflict. In fact, states have learned hard lessons and seem to be slowly opening up to cultural rights recognition and implementation. So what is the normative content of cultural rights? This is my third point. It's the more technical point. So 5 human rights are understood as cultural rights under international law: the right to education, the right to participate in cultural life, the right to enjoy the benefits of scientific progress and its applications, the right to benefit from the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which the person is the author, the freedom for scientific research and creative activity. I will focus on the right to participate in cultural life, which is the most all-encompassing of cultural rights, the concept of culture. So, according to the Committee on Economic, Social, and Cultural Rights, in a general comment it emitted in 2010, the committee considers that culture, for the purpose of implementing Article 15, which is on the right to participate in cultural life, encompasses inter alia ways of life, language, oral and written literature, music and song, non-verbal communication, religion or belief systems, rites and ceremonies, sport and games, methods of production of technology, natural and man-made environments, food, clothing and shelter, and the arts, customs and traditions through which individuals, groups of individuals and communities express their humanity and the meaning they give to their existence and build their world view, representing their encounter with the external forces affecting their lives. If we were to create 3 working groups here and say, based on this declaration, let's put together a law, you see how challenging this is, actually. It's not easy stuff, how to make this concrete. So the normative elements of the right to participate in cultural life, as they have emerged from the texts of international treaties and declarations and from the practice of international bodies, are non-discrimination and equality, freedom to create and contribute to culture. This also includes freedom from interference with the enjoyment of cultural life, freedom to choose in which culture or cultures and cultural life to participate. In other words, the self-determination of the person or the group in terms of to which culture it wants, in which culture he, she, the group wants to participate. Freedom of dissemination, very important for the academic context. Freedom to cooperate internationally, also very important for the academic context. Right to participate in the definition, preparation, and implementation of policies on culture. Now, we know that in human rights law, human rights, civil, political, economic, social, cultural, are interrelated and interdependent. So there are other rights that are very important for the enjoyment of cultural rights, such as freedom of expression, first and foremost, and is fundamental. Freedom of movement, freedom of thought, conscience and religion, freedom of association, right to health, right to an adequate standard of living, and others. Now coming to the cultural rights of indigenous peoples. I say this with emphasis, not just because I focus on that in many teachings, but because the extraordinary and historic UN Declaration on the Rights of Indigenous Peoples, adopted in 2007 at the United Nations, is the result of 25 years of negotiations, essentially between indigenous peoples and states. And during those years, this declaration was able to capture a very long and bold recognition of a body of cultural rights, which are very interesting, of course, and crucial for indigenous peoples themselves, but also for all of us in society to understand and for other groups in society to study. These are so bold, it is the first time that international law so boldly, after refusing cultural rights in 1948, recognized cultural rights. And I have I'm going to read this out, but I have made these copies so that maybe you can circulate and look through them. So, at least 17 of the 46 articles of the Declaration on the Rights of Indigenous Peoples are about cultural rights. The right of indigenous peoples and individuals to be free from any kind of discrimination, in particular that based on indigenous origin or identity. You can see as we go through how relevant this is also for other groups. The right to self-determination, by virtue of which indigenous peoples should freely determine their political status and freely pursue their economic, social, and cultural development. The right to maintain and strengthen their distinct cultural institutions. The collective right to live as distinct peoples. The right not to be subjected to forced assimilation or destruction of their culture, including mechanisms of prevention and redress. The right to belong to an indigenous community or nation in accordance with the traditions and customs of the community or nation concerned. Here comes also the concept of legal pluralism. You will see that coming in later as well. The right to practice and revitalize their cultural traditions and customs, and to receive redress for cultural, intellectual, religious, and spiritual property taken without their free, prior, and informed consent. The right to manifest, practice, develop, and teach their spiritual and religious traditions, customs, and ceremonies, to maintain, protect, and have access to their religious and cultural sites, to use and control their ceremonial objects, and to have their human remains repatriated. The right to revitalize and transmit to future generations their histories, languages, oral traditions, philosophies, and to designate their own names for communities, places, and persons. And the obligation of states to ensure that indigenous peoples can understand and be understood in political, legal, and administrative proceedings. The right to establish and control their education systems and institutions, providing education in their own language and in a manner appropriate to their cultural methods of learning and teaching. And the right to access, when possible, note that, to access, when possible, an education in their own culture and provided in their own language. This is the issue of resources that creeps under these matters. The right to have the dignity and diversity of their culture reflected in all forms of education and public information. The right to establish their own media in their own languages and have equal access to all forms of non-indigenous media. And the right to their traditional medicines and to maintain their health. practices. The right to maintain, control, protect. And develop their cultural heritage, traditional knowledge, and traditional cultural expressions, as well as the manifestations of their sciences, technologies, and cultures, including human and genetic resources, seeds, medicines, knowledge of the properties of fauna and flora, oral traditions, literatures, designs, sports and traditional games, and visual and performing arts. They also have the right to their intellectual property over such cultural heritage, traditional knowledge, and traditional cultural expressions. I could give a seminar on each of these rights. They're so rich, but we don't have time for that. So I leave this here. In addition, through other human rights bodies, what has been recognized in international law is the right to the protection of certain economic activities of indigenous peoples that are closely linked to their cultural preservation and development. So the state must respect these as cultural rights of indigenous peoples. For example, this is the case for reindeer herding of the Sami people and other Nordic peoples, because this is part of their culture. Let me come to the fourth and final point of this presentation. Why are cultural rights especially important today? I would like to say that there have been three important developments, first the very positive, in the last 9 years at the UN that contribute tremendously to the promotion and protection of cultural rights as human rights, as part of human rights law. And these are, one, the adoption of the UN Declaration on the Rights of Indigenous Peoples, the boldest recognition of cultural rights, also as collective rights as well as individual rights. Second, the creation of a UN Special Rapporteur on cultural rights by the Human Rights Council of the UN. And the main job of this rapporteur is the supervision of the implementation by states of cultural rights, bringing forth good examples and obstacles, studying the relation between cultural rights and cultural diversity. The first rapporteur, 2009 to 2015, was Mrs. Farida Shahid of Pakistan, and since 2016 is Professor Karima Benoun of the USA. And the third positive development is the adoption by the Committee on Economic, Social and Cultural Rights, finally, of the long-awaited general comment on Article 15 of the Covenant, which recognizes the right to participate in cultural life. So finally, this expert body shed its light and provides actually, it's very important because it provides a certain serenity and objectivity in how this right is analyzed. Now, my question is, what has changed in the big picture of the world between 1948 and today to have made this possible, actually, politically? First, the Holocaust during the Second World War was unfortunately followed by other genocides and mass atrocities that had cultural suppression as their elements. Second, the end of the Cold War has seen the rise, or rather allowed the expression of identities in an unprecedented manner, thus obliging the states to provide some recognition of those, or else face serious political and other consequences. And third, globalization has triggered in people the urge to confirm their own identities, while at the same time communication technologies bring cultures in contact at a dazzling speed. All these are connected, these reasons. So examples of recognition of cultural rights include, of course, the adoption of the Declaration on the Rights of Persons Belonging to Minorities, 1992, 2007, Declaration on the Rights of Indigenous Peoples, 2016, adoption of the American Declaration on the Rights of Indigenous Peoples, and 2019 we are celebrating the International Year of Indigenous Languages. So these are developments that we cannot not recognize as very positive. Why are cultural rights especially important today? The world's nearly 200 countries are home to about 5,000 ethnic groups. More than 150 countries have significant religious and ethnic minorities. About 370 million indigenous people live in more than 90 countries, representing about 5,000 languages. Out of the estimated 7,000 plus languages spoken today, 90% may have become extinct or face extinction in the next 100 years. So we can easily see what a great percentage this represents for indigenous peoples and their cultures. About 518 million people face restrictions on religion, language, ceremonies, and appearance. There are about 175 million migrants in the world, and asylum seekers represent about 9% of all migrants, around 16 million. In sub-Saharan Africa, only 13% of children in primary school receive instruction in their mother tongue. The newspapers daily tell stories that are loud and clear about the need to protect and promote cultural rights. The prevention of cultural expression of migrants and indigenous peoples is one type of story. The prohibition of teaching indigenous and minority languages is another story. The destruction of monuments that represent a culture is another type of story. In 2017, the International Criminal Court convicted Ahmad al-Mahdiya, former junior civil servant in Mali's Department of Education, for the destruction of 9 small mausoleums made from mud and a mosque in the middle of the desert. What the chief prosecutor of the ICC, Fatou Bensouda, called a callous assault on the dignity and identity of entire populations and their religious and historical roots. And this was the first case when ICC convicted someone for violating cultural rights. I would like to mention the element that may have triggered for some politicians an interest in cultural rights. Issues of conflict touch the human political imagination. From a human rights point of view, it is painful to have to evoke the dangers of ethnic conflict so that the politicians pay attention to cultural rights. Ideally, we should care about the respect and protection of cultural rights because of their profound significance for human dignity as human rights. But whatever the motivation for paying attention, finally, to this neglected part of human rights, it is now welcome and long overdue. One of the challenges in contemporary law and politics is how to ensure that the politicization of culture is a positive and not a negative development, and that it results in the respect and not the denial of human rights. Attention to cultural rights can have real and practical effects. It can help strengthen public policies for the respect of the identity of groups to whom injustices have been done, for example, indigenous peoples, and even mend historic injustices towards these communities by the majority population, as well as build positive intercultural relations. And since cultural rights impact so deeply on identities, even symbolic acts, I claim, can have a significant impact in society and set the stage for more positive changes, ones that would go beyond symbolism and moral aspects of policy and also touch on material demands that some cultural rights entail, such as language rights. An indispensable condition for such approaches, however, is the full and effective participation of the populations concerned. In conclusion, I believe that beyond controversies that may continue to exist, respect for cultural freedom, identities, and cultural pluralism within a context of a democratic polity is more urgent than ever. To recognize cultural rights as legal rights is a bold statement and key to state action. Thank you. So we have a little time.
I was wondering if you could speak a little bit about progressive realization and minimum core obligations and where cultural rights fit into that, because they are recognized as being part of the International Covenant on Economic, Social, Cultural Rights, but also there's a separate treaty, or declaration rather, that recognizes cultural rights. So I'm wondering if there is any jurisprudence, or if you could share a little bit about what part of this falls into progressive realization versus things, their obligations that states have immediately to undertake.
The work that the Committee on Economic, Social and Cultural Rights has done in terms of analyzing what progressive realization means, what minimum core obligations mean, is crucial. And if we are to take cultural rights seriously, we would start by saying that a minimum core obligation is non-discrimination. We start with non-discrimination. So, when you talk about, for example, language, all children, sometimes I have a PowerPoint, all children in the United States, without discrimination, will learn English. Okay? Is that real equality? Okay. Actually, if we think about it, it's not real equality if we think of children whose mother tongue is not English. So we have to take specific measures in order to realize this. The other is about the material aspects, meaning the budgetary aspects of human rights, of economic, social, and cultural rights, because they are not implemented just by not doing anything, obviously. So that's where we go deeply into checking how governments spend their budgets. If, for example, they are not going to do anything on cultural minorities, for example, through the media, there are many things you can do through formal or informal education. Then you can say, depending also on the economic level of the country, that the country has failed or is doing its job. For example, I continue to be shocked that in this country, you can go through school and not learn about Native Americans. I'm just shocked about it. I think I consider the obligation of the state to teach about this at the level of school. So there are many things that the state, if it really wants to take cultural rights seriously, it can do. Yes. Yes.
I have a question. So you mentioned the language is English. Does that mean there is a huge gap between the English-speaking country and the non-English-speaking country for these rights status? Thank you.
I brought this as an example of a state making the dominant language available to all children. Of course, all children should know the dominant language because they have to survive economically. And, for example, many indigenous communities also advocate for that. But what has been proven by extensive research is that children whose mother tongue is not the dominant language and they are taken to school in the non-dominant, in the dominant language, basically they drop out of school. We call them, instead of calling it dropout rate, we call it push-out rate. So these children either drop out of school or they don't really get a good education because mother tongue had not become available to them. This, what I am presenting, does not happen only in the United States. It happens elsewhere, in many other countries, of course, where this language education, mother tongue, is not available, unfortunately. But something I want to say, and I hope I raised enough of I don't know, suspicion or curiosity, is the fact that, look, for states have known or have thought that by killing languages, they kill ethnicities. This is the case. This is so. And it has also been proven by studies that it takes one generation to kill a language, but it takes 3 generations of sustained political will and action by the community concerned and resources going into this effort in order to revive it. So this is that's why I consider a big political, and I welcome, it's a political victory really, that we have this year as the International Year of Indigenous Languages. And we will have a decade actually coming up, starting 2 years from now, a decade on Indigenous language, because there is an excitement in the world about this right now, for many reasons, by the Indigenous peoples themselves and the minority, but by everybody actually. There is something happening in our world. That's why, since we are in Colombia, I want to tell you that I am disappointed that last year, that while Colombia for 2.5 years taught Nahuatl, which is a major indigenous language in Mexico, it stopped it in January 2019, at the beginning of the Year of Indigenous Languages. Anyway, so we have to see the importance, of this and to try to make things good at home, starting with our little space, which is Columbia University, Yeah.
Hi, thank you for your talk. I'm wondering about the loss of culture that happens when entire populations might be forced to move because of climate change, for example. Do you see any hope for applying cultural rights in that context, say in the Pacific?
Absolutely. Of course, there is cultural loss when populations need to move because of climate change. And actually, what is very interesting is going back to, I think it was 2015, I think it was, no, earlier than that. It was 2008, that the Inuit actually were the first that put a human face to climate change. For a long time, the discussions on climate change were like were just consumed by the sciences. People were not talking about the human aspect, what it means in detail. And the then president of the Inuit Circumpolar Council, Sheila Watt-Cloutier, who is from Canada, she took a case to the Inter-American Court of Human Rights. She took President Bush to the Inter-American, the government of the U.S., meaning of human rights, for violating the Inuits' right to be cold. So this phrase, the right to be cold, right, epitomized. It was just a phrase to capture what a whole culture has at stake, around climate. And at that year, she was, along with Vice President Gore, she was nominated for the Nobel Prize, and Gore got the Nobel Prize. So this is the little story of this. But we have many indigenous peoples that come, for example, to the Permanent Forum on Indigenous Issues and talk to us about the meaning of climate change, both, the desertification from African indigenous peoples, and also, of course, for example, in the Arctic, in Siberia, about sinking villages. And what it means for people and the fact that they have to be simply displaced. Whether cultural rights would help in this, I want to be realistic with you, with all of us in this brainstorming. Because cultural rights have not yet achieved, despite progress, this very strong status that they should have. They wouldn't be, if I were a politician, a tactician, a strategist, they wouldn't be my main thing, but I would definitely speak about what it would mean for the whole population. There was a question about a Pacific island where they were preparing the whole population to be moved to Australia. And people were talking about what this would mean for a whole population of a Pacific island to be put in this setting of what is today's Australia. Of course, loss of culture. Yes.
question, please. You mentioned the Convention for the Rights of Indigenous Peoples in 2007. There were also, around that time, 2 UNESCO conventions, one on the intangible cultural heritage in 2003 and one on to protect the diversity of cultural expression, in short, in 2005. So I wonder what created momentum at that moment, and you mentioned why governments may shy away from giving cultural rights or wanting to engage in the conversation, but based on your observation, what encourages governments to make these conventions happen or sign in and move things forward?
Yeah, that's a very good question, and I was wondering myself, looking and examining UNESCO's work, and what you see in UNESCO is that it's the state, how can I say, appropriating cultural heritage. So the state speaks for its cultural heritage. For example, it might be Cusco, the Maya civilization. It's the state that will take it and will not ask the indigenous peoples of Peru. And I'm very happy, actually, that the special rapporteurs on the rights, on cultural rights, have spoken about the significance of not alienating people within the state of what is their culture. So there has been a statism, if I can use this word, in doing that. The second, which has been actually quite a negative practice of UNESCO, is the declaration of World Heritage Sites without, just with the consultation with the state, with the government, and without any consultation with the people's concerned. So what you have had happen often is that they declare a place, a park, heritage site of humanity, and then they remove the people concerned, whose site this is and creation this is. And this has been heavily critiqued. But still, UNESCO is resisting. And on the 2005 Convention on Cultural Expressions, the protection of cultural expressions, this is a commercial treaty, if you look at it, for real. It's not a human rights treaty. Human rights asks what goes to the dignity of the creators of a culture, of the product, of its individual, of the group. What is the culture of the group? Asks that. And how is that protected and respected? That's the question. It does not ask whether French rock music will be protected or not. But at that conference, that was the question. It became an international commercial treaty, essentially. I mean, we can all, if we are not in a seminar mode like we are now, but if we are in an advocacy mode, we can say, we are so happy that UNESCO has adopted these conventions and declarations and so on. And I am also very happy. I can be an advocate like that. But in UNESCO, there is a profound resistance to human rights. I'll give you an example, recent one. There has been a proposal already a few years back to have actually a convention on the protection of languages, language diversity. It has been flatly rejected by states. They couldn't even start the drafting, just for us to see, the thing behind. And another phenomenon that you have among states is that while they will respect, promote, and even be proud of seemingly innocent folklore, right? But they will not respect, they will not accept the languages. They will allow people to dance to the music, but not to sing the words. Many examples like that around the world. So, for me, a human rights job that I have to do is to also bring awareness to this history of the state, and how the state has behaved vis-a-vis cultural rights, and why. And why it's a good time now. Okay, whatever has created this better time, I know we are in difficult times in our world, but whatever has created an opening, let's have this opening. I mean, you remember in Kosovo, the big thing was that they would not allow them to teach their language in schools. And that's what created an outburst. In Sri Lanka, the same thing. Language was the reason of tremendous conflict. So.
To end on a positive note, what would your advice be to law students and activists who are interested in the sphere of cultural rights today? What spaces that are progressive that they could observe or join? Where's the good action happening?
Yeah, I think I read you the recent topics of reports of the Special Rapporteur on cultural rights. Professor Karima Benoun is a law professor in UCLA. Because these are new areas. If you read even her reports, she's a jurist, she's a law professor, you see the new terminologies, new ideas. For example, this most recent report on cultural spaces, the importance of of public spaces for cultural rights. So she analyzes that. So these are new things, and each one of us can find our niche. For example, I am quite interested in how, and this question didn't come up today, so maybe times are changing. You didn't bring up the women's issue, because very often people, when I give these talks, they say, what about culture and they oppress women, and, this kind of thing. But this comes from a misunderstanding that everything around culture is vilifying, is negative. Of course not. We cannot live without culture. It's like oxygen, culture, So there are some bad things, but we have to have it. Without it, what are we without the culture? So, but I'm very interested in how, in the role of women in specific communities, women as changers of cultural practices through the exercise, the free exercise of their cultural rights. Because cultural rights are not the content. The content is not static. Like culture, it changes. So what is my culture today, the way I define it, maybe, in 20 years, I as a woman, mother, grandmother, maybe I will have another idea about it. This is also super interesting, and I'm very interested in how the women can contribute and do some case studies. I would like to see that. I would think this, and again, here you have to marry anthropology and law in order to do this study well. So, and youth, excuse me, yes. I put the students that I have in the cultural rights seminar that I do, through this, I give them as assignment the idea of youth as culture changers and interpreters. I find that wonderful, and I think since we are, in a university, it's very interesting, based on this framework, to think, what does this mean in my community, in my city, in my university, for that matter. So.
Thank you very much, Elsa, for joining us today. Please join me.